Hello, hello, hello. How are you doing today? My name is Attorney Jumoke Oladapo from the Ivylaw Law Office in Greenbelt, Maryland. Hope you had a good week so far. We are midweek, and right here and now, we're on to the immigration live questions and answers session. Thank you so much for taking out time to be watching this. Please send in your questions, and you can do this by first subscribing to our YouTube channel, Ivylaw TV. When you subscribe, you'll be able to send in questions, and we'll be able to answer those questions. Attorney Will is off today, so I'm going to be taking those questions for you. All right. I have some questions here ready that I'm going to handle, and I hope that you'll benefit from our responses today. The first question I have here is this: how would I prepare for my marriage green card interview? So I believe the person that asked this question, first of all, is married. Second, has put in an application for green card, and the U.S. citizen spouse has filed a petition for him or her, and now your interview date is up front coming. Usually, you get an interview notice right now about 3 weeks to the interview date, and it's going to have instructions. The interview notice is going to have instructions on it. It's going to have the date of the interview, it's going to have the location, it's going to tell you that you should come along with your spouse, the petitioner. So I'll advise that you read this interview notice very thoroughly to give you a good understanding of what is expected of you. So, first off, if you have an attorney, I would want you to schedule a time with the attorney to prepare you for the interview. If you have a mock interview ahead of time, then you are more better prepared to go to the interview location before an officer. Also, make sure you attend your interview with your U.S. citizen spouse. If you don't, what will likely happen is that that interview will be postponed for your spouse to attend with you. And you have to have a good reason, a good cause reason why your spouse is not attending with you for you to be able to have it postponed. You can request for a postponement by um, calling USCIS or sending a request. But if you want to be safe, it's better you send a letter into the field office where the interview is going to be taking place. And after that, um, if possible, go to make sure that you are properly scheduled for another date. Secondly, be present with your spouse. I've said that before. Thirdly, you have to gather all necessary documents, your biodata documents like your passport, your birth certificate. Take along your originals, take along the interview notice with you because that's what will admit you to the interview location. Also, it's important that you go with a lot of joint documents. So any document that will prove the bona fides of your marriage, make sure you go along with such. For example, your joint bank account. For example, if you have insurances together, the birth certificate of children you have together, and such. The more documents regarding the bona fides of your marriage that you provide, the better to provide a strong case for you. The officer will usually ask you, what documents did you bring today that you'd like to submit? Please make sure you provide such when asked. Also, advise that you get to the interview location early, at least 30 minutes before time. During COVID, they allow you to get in like 15 minutes before the interview time. Make sure you're properly dressed. Don't give a wrong view of who you are by inappropriate dressing. Make sure that both of you are well prepared with your attorney. If you have an attorney, it's always good for your attorney to go along with you. Those are some of the preparation tips that I'll give to you right now. If you need more services, you can definitely contact our office. We have what we call interview preparation meetings with a client, which is usually a 2 hour meeting in our office to make sure that you are properly prepared for the upcoming interview. I see a lot of people that they say, well, I don't need an attorney to go with me. Um, some people are able to do that without an attorney, but it's better if an attorney goes with you, because if something happens to go wrong, then the attorney is there to be able to intervene and ask for a supervisor. So that's how you prepare for your green card interview. For more information, contact us, schedule an interview preparation session, and we'll make sure you're well prepared. Thank you. The next question: what is the difference between a fiance visa and a marriage visa? What's the difference between a fiance visa and a marriage visa? A fiance visa, also known as K1, is for those who are not yet married, who intend to get married. And this is a non immigrant visa. A lot of times when you have the intention to bring a fiancé over to the United States, then you're a US citizen and you're likely to get married to the person. You can apply for this non-immigrant K1 visa so that the person comes in on this visa. And the requirement is that you have to get married to the person within 90 days. I suggest that you can make use of this visa. Number one, it used to be like quicker to process. Um, right now, maybe not. Number two, it gives you an opportunity to really spend time with the person within the 90 days. If you're unsure that you're not going to, if you're sure you're not going to get married to the person within the 90 days, or if things don't work out, the fiancé can definitely return to the United to their country of residence, because they will not get married to you within the 90 days. But the requirement of the law says if you come in on a K1 visa, make sure you're marrying the person within 90 days if that works out. However, the marriage visa is an immigrant visa. The marriage visa is this: you're already married to your U.S. citizen spouse, either within the outside of the United States, probably, or within the United States, but the spouse resides outside of the United States. Then you're going to file an immigrant visa petition, petition for alien relative for this spouse. And after that, the spouse will go through the consular processing to go for an interview at an embassy or consulate outside the United States. And they will be issued a visa, a lawful permanent resident visa, to come to the United States as a green card holder, if they're approved. That's the difference. So the fiancé visa is a non-immigrant visa, and the marriage visa is an immigrant visa. The processing time for the immigrant visa used to be about 1 year to now to about 1.5 years. It's a more certain visa. It's a more certain process. Non-immigrant visas are not like as certain as immigrant visas, because non-immigrant visas are, subject to the discretion of the officer interviewing you, among other things. So if you have a situation in place, make sure that you speak with a lawyer to so that the lawyer can, based on the fact or your circumstance, give you an adequate recommendation of what should be most suitable for you to do. For some, it's advised that they can go through the K visa. For some, it's advised that they go through the immigrant petition. Also, there used to be a visa called K3 marriage visa. Um, that means you're married and you're applying for a non-immigrant visa for your spouse. That used to be available when there was a lot of backlog with the green card petition, consular processing. It's less used when the processing period, the priority date was, became current. So it's not as popular, but there's also this third option of a non-immigrant visa for your married U.S. citizen. Um, all right. The next question: what happens if you don't get a divorce after receiving a green card? I'm sorry. What happens if you get a divorce after receiving a green card? I'm assuming that you probably got your green card through marriage to a U.S. citizen. Life happens, okay? And if the marriage is not working out and you happen to get a divorce, um, let's say you already got the divorce, and the green card is through your spouse. If your green card is a 2-year green card, that means you have to file to remove conditions 90 days to the expiration of the green card. It's called conditional residency. If by the time of the conditional residency you have to get a divorce or you're divorced, that means you can file a joint petition to remove conditions with your spouse. Fortunately, the government and immigration recognizes that such a situation can happen, and there is a waiver, or I'll say some exceptions to the rule, so that you will be able to file your petition to remove condition under the waiver or the exception for not filing as a joint petition. So one of it is if you're divorced, then you can file a 751 waiver based on divorce. One of it is if you've been subject to like domestic violence or VAWR situation, you can file based on that. Another is extreme hardship. If leaving the United States is going to cost you extreme hardship, and you're not in that relationship anymore, maybe you're still married to your U.S. citizen spouse, and you've been subject to a lot of abusive situation, and you're a victim of domestic violence and all that, then you can file on the exception for VAWA or the exception for extreme hardship. Those are the situations that has been provided by um, the law, immigration law. If you are faced with such a situation, it's not an easy application to do at that point because there are different things that you have to prove. So I'll advise that if you have this type of situation, make sure you speak in with us or any other um, experienced immigration law attorney to help you with navigating this situation. You can still become your green card can still become, the condition can still be removed, okay, so that you'll get your 10-year residency. If you don't do anything about it, at some point, you're going to get your conditional residency terminated. That means your green card is going to be terminated and you're going to be put in removal proceedings. You don't want this to happen to you. So if you're having marital issues and your your spouse filed for you for green card, make sure that you're contacting an immigration attorney to help you. If your marriage is over 2 years, or if you got a 10-year green card when you got it and your marriage is subject to divorce or you had to get a divorce, um, if you've not been married for 3 years, okay, and if you've not gotten your green card for 3 years, that means you have to wait for 5 years before you're eligible for application for naturalization to become a citizen. So getting, instead of being eligible for citizenship 3 years as based on your marriage to a U.S. citizen, that means you have to wait for 5 years before you can become eligible for citizenship. Hope that answers your question. The next question I have is, how do I prepare for U.S. citizenship interview? All right. This is a good one as well that is going to be a little similar to what I answered before. So I'm assuming that you've been a green card holder within the statutory time, whether 3 years if you're married to a U.S. citizen, or 5 years on any other condition, or 1 year if you were on asylum, and then you become eligible for to apply for naturalization to become a U.S. citizen. Or if you want to get your citizenship through your parents, and then you get an interview. You'll get an interview notice again. Usually around here, you get an interview notice like 3 weeks to the interview, 3 weeks to a month to the interview. A lot of people think they can navigate US citizenship or naturalization interview by themselves. Some are okay if they don't have a baggage of criminal experience or a whole lot of other issues. It's always better to have an attorney prepare you and go with you. And this is why. During a naturalization interview, all your record will be pulled from when you got a visitor's visa to come to the United States. So your DS 160 and all your background check will be pulled to make sure that there's nothing that will make you, um, that will deter you from becoming a U.S. citizen. If there's any, then you could be in trouble. All right. And you will be questioned on any issue that the immigration officer thinks is not okay. Also, it's good for you to know that you need to pass the U.S. Civic questions, U.S. history questions. So there are some 100 questions and probably a little more, depending on when you apply for U.S. citizen. Make sure you study those questions. Make sure you know the answers to those questions, because there will be a random pull of about 6 questions, 6 civic questions, and you need to um, pass the 6. There'll be 10 questions asked you, and at least you'll pass 6 of those questions. Also, you have to be good and strong on English language, reading and writing and understanding your English. So for those who have in if English is a second language and you don't understand English, or you can't read and write, that could be an issue. You want to speak with an attorney, an immigration attorney, to see how you can navigate that. So prepare for your civic questions. Make sure you know how to read and write. And also you have to prepare to know all the answers that you had in your application. Make sure you schedule to practice with an attorney. If you have an issue, there are a lot of things that the attorney will look at to make sure such are resolved. I'll always advise you go with as many documents as are immigration related as possible. And also make sure you go with your notice of appointment to get you in. You're always welcome to contact our office to prepare you for your citizenship interview. If you have any doubt or if you have any concern that may lead to your denial, make sure you contact an attorney. If you have criminal backgrounds or a criminal offense from the past, make sure you contact an attorney. If, for example, you've voted before or you've registered to vote, make sure you contact an attorney. There are a whole laundry list of questions that will make you not to be able to become a citizen. Also, good moral character is an issue, and it's so important when it comes to becoming a citizen. So you want to make sure that you're a person of good moral character, at least 5 years before your filing date, up to the date you become a citizen. This is some of the things that I'll speak about how you prepare for a U.S. citizenship interview. And we wish you the best. It's always better if you have that opportunity to apply to become a U.S. citizen and to be a U.S. citizen. There's so much benefit from being a U.S. citizen, which includes the right to vote in a U.S. federal election. And the next question I have is, what income requirements are there for a marriage-based green card sponsor? So, if you're filing a petition for a spouse in a marriage-based green card, first of all, the petitioner is your sponsor for the purpose of affidavit of support. That means that your income will be asked. You have to be eligible for to be a sponsor, and USCI has as like a guide, poverty guideline I-864P, that shows and gives you the income eligibility requirement based on your household size. So, for example, if it's only you and your U.S. citizen spouse, and there are two of you in the home, then your spouse this year have to make if you are in the military, then your guideline is different from other people by state. Okay. So if you're in the military, you're looking at 100% poverty guideline requirement. If you're not in the military, you're looking at 125% HHS poverty guidelines. So most of our clients, for example, in my office, um, go on the 125%. So if you are a family of two, then the minimum income your sponsor or petitioner can make is $22,887 per annum. If you're a family of four, then the minimum is 34,687. The guideline changes from year to year, and you have to complete this as part of your I-864 affidavit of support. Okay. If your petitioner, for example, does not meet the guideline, there are other requirements, there are other ways by which you can have someone sponsor you on the affidavit of support. So, in that way, you're looking for a joint sponsor. The joint sponsor has to meet the income requirement for himself or herself, household plus you. So, if, for example, your joint sponsor has a wife and two children, That means it's a four-size household. That means your joint sponsor has to make more than 34,687 plus you making five. That means your joint sponsor has to make over 40,587. So you have to be thinking about that. There are peculiar situations that we'll look at for those who are not W 2 income earners, for those who are self employed, for those who are business owners, for those who need to look at their stocks or bank accounts to make part of this income eligibility requirement, or those who have to look at other assets that they have. There are different criteria, even though the I-864 form looks simple, but it's so important. And the reason is that the United States does not want you to become a public charge. No person of public charge as a green card holder. They don't want you to be going on Medicaid. They don't want you to be going on um, T, I think it's called cash assistance. However, there are exceptions to the means test. Okay, so for example, if you have to take emergency Medicaid due to, let's say you have an accident and you have to go through emergency surgery, there is an exception to that. For example, if you've earned like 40 credits in Social Security income, that's an exception. There's a few other exceptions to the means test for the poverty guideline requirement. If you can't do this, make sure your attorney is assisting you to get this done. This is a mandatory requirement for you to get your green card. So don't overlook it and don't make a mistake. All right. So thank you so much for listening to this Q&A session. If you have any further questions, feel free to contact our office, Ivylaw Law Office. Our phone number is 301-276-0887. You'll find the phone number as well on the um, below. Our website is www.ivylaw.office.com. Would like you to please subscribe to this YouTube channel and like, share, and we'll look forward to really helping you to take the next step towards either becoming a green card holder or a U.S. citizen, or to resolve any other immigration issue that you may have. Our goal as immigration lawyers is to be able to help our clients live and work in the United States with legal status so that they can achieve their American dream and one day become very successful members of this society. The more we are able to help you, the better. Please feel free to contact us. Feel free to ask your questions. We'll see you again next week at 2 p.m. on Wednesdays. Thank you very much for your time today and hope to catch you next time. Bye.